Yep.
There has been another school shooting at Saltmarsh High School in Great Bend, Kansas. What has happened is that Trevor Wild, a 13-year-old student, went to a chemistry classroom with a shotgun and killed 3 different students. We are here on the lawn of one of the parents of the slain students. His name is Matt Stover. Matt Stover, what do you have to say about this incident?
That daggone Trevor Wild kid shot my son. Didn't matter he had a gun, he would have killed him anyway. He would have killed all 3 of them if he had had like a rock or a club or even a shard of glass, for crying out loud. Get off my property!
From a grieving parent. Back to you, James.
Mr. Stover, I'm a representative for the NRA, and we're holding rallies because the Kansas legislature is trying to have stricter gun laws, and we were wondering if you would like to speak at our rallies.
Sure, I don't see why not.
Okay, great, because we're having one right now. Ladies and gentlemen, Mr.
Wait, what?
Stover.
Like, right now?
Right now.
Oh, shucks. So, I don't think guns necessarily are bad. I mean, you can take my gun, stick it out in front of my porch, I ain't gonna kill anybody, but like I said, I think it was that Trevor Wild kid, not the fact that he had access to guns. I mean, he could have killed kids whether he had a rock, club, even a piece of string. Thank you, I guess.
Okay, so now we are going to go to the court and look at the verdict. Oh, never mind. Oh, sorry.
Did the reporter have something she wanted to say? Yeah, no, like I just watched this thing on TV. It was like this idiot, right? Like he was going for the NRA and he was saying things like, oh, guns don't kill people, you know, people kill people and all this crap. Like, no, I gotta write an editorial about this, right? Like, for the Campus Monthly, you know, like I'm the editor there, you know, I get to do things, my opinion matters, and my opinion is right, and deserves to be heard. So, okay, so like, I'm gonna write this thing, right? And I need to like sound professional, because you know, I need people to like pay attention to it, and like do things with it, and like, all that stuff. So like, okay, what I'm thinking is it's gonna go something like this, okay? In the immediate wake of the Saltmarsh school shootings, Matt Stover told television viewers that the easy access to guns had nothing to do with his son's death. This was what's a good word to use? Like a smart word, like, stupid. This was a stupid remark, but we wrote it off to the confusion any grieving parent would be suffering in similar circumstances. But now, Stover has become the poster child for the state's gun nuts and the big bucks express of the NRA. How Stover can continue to argue that the fact that a 13-year-old boy, yes, boy, can take a shotgun to school and kill 3 people has nothing to do with the murder of those 3 kids is irrational. Like, do you think irrational is like a good word? If you guys like give me a better point, like, okay. No, it's insane. Yet every day we see another insipid remark from Stover quoted in the press, and given a special credibility because he is the father of one of the slain students. Any other jerk who said this would be probably ignored. It's time for the newspaper, TV stations, and the rest of us to ignore Matt Stover. He no longer deserves to be heard. Does that sound good? Yeah? Okay, publish it.
Libel lawsuit!
Okay, now we're going to go to the court.
Okay, so as you guys just saw, this case is dealing with a school shooting that occurred. 3 students were killed. A lot of parents were interviewed, but only one parent, Matt Stover, said that Trevor Wild shouldn't be found at fault. Or Trevor Wild should be found at fault. It's not the fault of a gun. If he had something like a knife or club or even a rock, he would have killed someone if he wanted to kill someone, so he should be found at fault. So after these shootings occurred, people who were against Second Amendment rights were pushing for stricter gun laws. So as a response to that, the NRA started holding gun rallies at multiple gun clubs in the area. They approached Matt Stover and asked him if he would like to speak at these events, along with other Second Amendment advocates, and he agreed. since he continued to make the same remarks that he initially made about Trevor Wild, and he kept saying that the guns weren't necessarily the problem. The Kansas Monthly, a state magazine, said that he was crazy, he was making insensitive remarks, he was a jerk, all sorts of really inflammatory remarks. So Matt Stover sued for libel. So then the question becomes, is he a public person or a private person? Matt Stover said that he was a private person because he was bootstrapped into the spotlight, but the Kansas Monthly said that he was a public person.
So then, this brings us to rhetorical hyperbole, which is defined as a statement so exaggerated that the readers or listeners know that it is an opinion, which, as Mallory clearly stated or showed, this falls under rhetorical hyperbole. So then, the Ullman test. The Ullman test was established in the Ullman versus Evans case to determine if a claim is an opinion. To determine if it's an opinion, you have to prove 4 things. The first question is can the statement be proven true or false? Because the statement saying that Stover is stupid or makes stupid remarks or is a poster child for gun nuts or arguments that he is irrational or insane, the statements cannot be proven true or false because the NRA does not think that Stover is these things, but clearly the Kansas Monthly does. And the readers reading the Kansas Monthly can go either way on those opinions. The second is the words, what are the meanings of the words? So because these words are like stupid and insane, I think he's referred to as being a jerk at one point, these can't be defined. So anyone reading the Kansas Monthly, they all have different opinions and definitions of these words, so therefore making an opinion. The third thing is the journalistic context of the work, and as we showed before, it's written by an angry reporter in the heat of the moment, who's clearly against what Matt Stover is trying to advocate for. And the social context of the work is gun control laws, so that is clearly a highly debated topic, not only in today's society, but also clearly in Kansas at the time of this case. And lastly, the Milkovich standard was stated in the Milkovich versus Lorraine Journal Company case, and this is where pure opinion was defined as a statement that is incapable of being proven true or false, which, as we stated before, is an opinion because you can't decide what was said is true or false.
So our verdict, because our decision, because of our opinion that he was a limited public person, a limited liability public person, that he did thrust himself into the spotlight when he continued to speak at these rallies. Because of that, he has to prove a lot of things. That it was published, that it was easy to identify, that it was defamatory, and that it was false. A public person was defined in Gertz v. Welch when it said that those classified as a public figure have thrust themselves into the public forefront to influence the public. Like I said, when he continued to speak at the NRA rallies is when he continued to make himself a public person and was no longer a private person. So our verdict was that because of his status as a limited purpose public figure and the phrasing of the editorial being more opinion than fact, that Stover wouldn't be able to hold his libel case and win his case.
Are there any questions?
What is the Gertz v. Welch case?
Let's see.
You got it. Gertz was an attorney hired by a family to sue a police officer who had killed the family's son. In a magazine called The American Opinion, John Birch accused Gertz of being a Leninist and a communist forefronter because he chose to represent the clients. And then Gertz sued for libel and won the jury verdict of $50,000 award, but lost his libel suit because the trial judge found that the magazine had not violated actual malice.
New York Times Company v. Sullivan came first, but since it dealt with public official Gertz v. Welch, started defining, what a public official is, what a public figure is, what a private person is, to make it more specific so you would know if you would have to prove actual malice, which is reckless disregard for the truth and knowledge of falsehood. Any other questions?
I guess I got one. A lot of these cases where they're suing for libel, does it usually originate with somebody in the heat of passion just spouting out something in a magazine or a newspaper that gets this all started?
Not necessarily. Sometimes it's just a piece that was put out that maybe wasn't worded very well, or is like it's defamatory. Like, to be libelous, it has to be defamatory, and for it to be defamatory, it has to injure the person's reputation or whatnot. And those can be like planned out ahead of time. Those can be something like even a news report, like on the air, to end up in a libel lawsuit.
Okay.
So these can be things that are like poorly researched, or it's biased in research, so you know that it could be false or something like that, or it could just be something in the heat of the moment.
Okay. Thank you. Any other questions? You guys did great. I learned something today. Thank you.